So I'll direct this question to Heinz. Is as a German practitioner, how does it help from the enforcement aspect, from the litigation aspect? How, like, has AI influenced German practitioners anticipate examiner behavior?
Sorry. Thank you so much. First of all, maybe if we start with the examiners and their behavior, yes. In the EPO, the career of an examiner depends largely on how many office actions you do per year and all these things. And we have very often the impression that what the examiners does is created by a button, and then comes a clarity objection, because that you can issue out with the help of AI without having understood the invention at all. And then we have the first point for this year of the 12 office actions which you should do per quarter in order to be promoted and get more money. So this is a little bit sarcastic. But of course, we develop also, I mean, Matthias is for a number of years already is a partner of mine in Böhmer & Böhmer, which I have founded in 1972-73. So I'm a physicist. I was an assistant professor for polymer physics, and then I studied law, what normally patent attorneys don't do, and then I did what I do now here, for example, to work with capable young people who understand AI like Matthias. I think it has something, I see this in my personal field. I have a lot of demand, for example, for freedom to operate opinions, and the search is to find, first, prior art that could be, no, not prior art, patents that could be infringed by products of certain of my international, also domestic clients, that can be identified much better with the help of AI tools, whatever here, for example, Matthias and his team in my firm are creating. And it has also a different field still, or maybe similar. The next step is a search, how can I destroy these patents? Because the typical thing is 10 patents could be infringed. To do really, you think, oh my God, we have to do something. The most expensive thing is we have to construe around and to avoid that. So let's try to kill that patent. So search, please, worldwide, prior art, one button, every thing comes up. So I'm personally of the opinion that 90 to 95% of all patents worldwide are invalid. So they can be attacked. I am much better and more inclined to destroy patents personally than to enforce them, and because they would be valid. Interesting things, I do a lot of litigation, practically only that, but I'm usually on the side of companies from Greater China, companies from both parts of China. So Indian companies, German companies who are attacked by the big trolls of this world, and they say we have a standard essential patents. We have 1,020 standard essential patents. Out of them, I would say a little bit less than 10% are standard essential. The other 90% you can forget, you can throw, either not enabling because training data are not there for generative AI, patent is invalid, and all these things. And then AI helps a lot. And one of my role in the firm is, I mean, first of all, I manage the firm, but secondly, it is to have people like Matthias, for example, who can then develop the necessary AI tools for this. Because then you need to have somebody, and this is at the moment the task on which he is working, how for little money, very quickly, you can, in the SAP portfolios, which comes from San Diego, Qualcomm, comes from Sweden, Ericsson, comes from Finland, Nokia, whatever. I don't wish to discriminate anybody here, but then you can already sort those so-called SEPs out, which you better forget, because they can be destroyed, or they are not used, or not necessary at all to make your phone here in Bengaluru talking with a phone in San Diego or something like this. And that is, without AI, very difficult. And I'm eagerly looking forward. He knows every day, practically as my evening prayer or whatever, when I sit with him here on this journey for dinner, for example, that I say, when do we have a tool which my people in Shenzhen can use, for example, to identify the real SEPs, which then need special treatment. They need then to be subject to freedom to operate. You must put some currency at the side how you can buy a license, because the big patent portfolio holders in this world don't wish to be paid in US dollars or in euro, at least mostly not. They wish to be paid in cross licenses. So what you do is you create a portfolio, and creating a portfolio is not legal cost. This is just to create a special currency, the only currency which big portfolio owners accept. They wish to have the freedom to operate themselves if they are partly at least producing or licensing companies like Qualcomm, where they wish simply to give their licensees, but they also make, of course, devices, components, whatever, to guarantee them, if you use that and that, we have already got the currency by cross-licensing to allow our licenses to use that license from Nokia, for example, who, as we know, don't make rubber shoes anymore, but they have, for good reasons, went into the phone business, the mobile phone business, which unfortunately another client of mine from Redmond bought. That was the biggest, I think, money-sinking acquisition which was done in the last 20 years, but that's a different story. So, I think AI is inevitably used by anybody who wishes to do something with licensing, cross-licensing, litigation, invalidation particularly. Without that we couldn't do it. And the way Matthias went with his one hat, where he is a partner of mine, also he's not a physicist only, he understands really AI. I know what AI, I like this thing here. I know what AI can do. How AI does this, I really don't know. Yeah, but very reliably. So he transformed in the firm, in my clientele, whatever, others also, transformed our analog procedures into digitalized procedures, to do things much faster, to do it much quicker, much more reliably, etc. And besides of that, also founded then a firm where I do not participate in, but we give advice to that firm, which is called Patent Maker, which has most, I would say in Germany at least, the most advanced drafting, office action handling, FTO, hopefully soon SEP handling AI instrument in the world. So I believe it is without AI, even for a very small firm, not possible to do freedom to operate and invalidation and patent litigation work. It's not any more possible. That should not lead to the fact that not persons like Kevin, for example, sit there and give some advice to a client what he best should do. This is something we can direct things, but there must be somebody in that team. And if the firm works with another AI specialist, something like Patent Maker or whatever, which is used by many German IP firms in the meantime, like our instrument Genies you probably use. I was created with my intervention somewhere in the 95, 96, long time ago. But it's also our original ideas digitalized in a reasonable manner. I think without AI you are dead or will never come to life. And so, yes, very important. Thank you.
So, long and short of it is that AI is a double-edged sword, probably. For SCP, we have a lot of issues when it comes to over-declarations. A lot of companies are doing that.
Yeah, just a comment. When I talk about over-declaration, I never forget to say that the people who do this don't do this in order to make other people angry or for nothing good purpose. We have case law in all important jurisdictions of this world. If you forget, whether intentionally or really forget, to declare something which you had in development in the standardization process already, then comes the ambush situation. And nobody wishes later on to hear in a court, oh, sorry, you knew this already at the time when you were sitting in this nice little Germany AG in Frankfurt to define a no phone standard. And United States, the same thing. IEEE is very nervous then. So this is why they over-declare. They do over-declare because there is nothing wrong in this, except that you have the risk, of course, that later on ugly people like me, for example, will destroy many of your patents. But that's a different story. But you should better over-declare than under-declare. Under-declare is life-threatening.
So just to add to that point, so when you're using AI as a tool for, say, for SAP standard essential patents, the flip side of that is the inventorship of it. The aspect of what would be a person skilled in the art, what would be obvious to an AI. So if you're using an AI tool and it comes up with a patent, an invention, so what would be considered as a person's, ordinary person skilled in the art?
Can I say something on this? Okay. I have a lot to do with this question. I work closely in many conferences and also not conferences only, but in practical work with the chief judge, presiding judge of the Patent Senate of the German Supreme Court, who is Dr. Klaus Bacher. And he wrote personally the German Dabus decision 2 years ago and cleared things forever as far as Germany is concerned. And the model is used by Japan in mainland China. It is definitely decided in a convincing manner that only a human being can be the inventor. And there, AI is a tool. And you see this, for example, when you just come into a situation where somebody has this idea to use a generative AI, let's say, which makes new turbine blades out of flight data, temperature control along the turbine blade. You get totally new forms of the turbine blade. Who is the inventor of that? Well, we have learned in our early days, I think, well, you are much younger than me, of course, Kevin, but I have reached 86 anyway. But what I do with passion. And I can only say, when I learned to patent law, or tried to learn it, I learned it actually for a certain extent, otherwise I would not be a professor for intellectual property law. The only one in Germany who is not a lawyer. I'm just a patent attorney. So, patent agency, Americans would say. But then you come to the point where you would think, I could use this machine, which consists of a data collector, and an AI system and a computer and a three-dimensional design maker or something. That is the machine. And this did until today only make in the marketplace turbine blades. Very nice ones, possibly inventive ones. Nobody could foresee that structure here, and that machine is patentable, of course, because there is a human inventor in that machine. Now somebody comes, I have a similar problem with the brake discs of bicycles. I wish to have less material where there are lower temperatures, and I don't need so much material. It is better, not so abrasive and whatsoever. Let's try. I take this machine which they use until now, since 20 years, no, it didn't exist yet, since 1 year maybe. This is a fast developing area in which we are. He used that for turbine blades. I have a similar problem. Let's look what it does with my disc brakes in bicycles. And out come a new disc brake with less material here, wonderful miracle properties. Who is the inventor? The machine did it all, except to create the task. And what we have learned in 1970, 72, when I started to be interested in physics, later on then for patent law, was an invention consists of a problem to be solved and the solution of that problem. And here is, which is now, the combination makes up the total inventive idea. Now comes the first one. Here is our person interested in the disc brake, which for bicycles, which should be improved. And he has this idea what could possibly possibly use this system for creating new disc brakes. Then the one part is solved by that person who is always, until today. Klaus Bacher from the Supreme Court in Germany says, maybe in 10 years, and I give you a scenario how that could be done then and look like. Today, it would always be a human being who sets some generative AI system onto a certain task. The task is then automatically solved more or less by the AI system with computer design extruder or whatsoever. And that is the inventor. He uses a tool. And that tool can be very sophisticated. Without that tool, he could not do anything. But to have this idea, setting it onto a new problem, that is then the sole inventor. And he uses a very sophisticated tool. Now we come to a different world. Let's say you have a machine, we just discussed it in the car actually, when we came here. You have a, let's say, some generative AI, what can do the following. When there is a number of human beings, it has been designed to put these human beings, divide them into certain quarters, certain compartments. There are the good people, there are the bad people, there are the semi-binary, I don't know what people, and it does this very reliably. And now you put this machine into front of a classroom, like us here, and the machine is not told what to do, sits here and all of a sudden starts to divide the people here in little squares where they all sit. Nobody gave that task. Who is then the inventor? And I said to Klaus Bacher, and he has not yet an answer for that, I said, the inventor is the one who put this machine in front of this room here. That is the inventor. So the last human being bringing the whole chain of solution, creation and solution, and also the solution for that into work. So it is always at the end of this whole crowd of people, or at the beginning, better to say, there is a human being. Everything else is a tool. And even if a wonderful mega painting piece in the style of Leonardo da Vinci and the machine does this, I could hardly make a little pencil drawing, something like that. But I created at least the turbine wheel in my own trademark of the firm Böhmert and Böhmert. I had this idea in '72. I thought, we are technical people. We all were scientists at that time, and we have also lawyers. So they should meet, maybe in the sense of what the firm does here. And what can we do? If you put paragraphs, we use in Germany for paragraph, article in American language, paragraph, signs next to each other, clearly legal, paragraph 1 is 24 and whatsoever. And I said, wait a minute, we make a turbine out of it, which is now paragraphs, 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 you see it up there somewhere, and this is then legal and tech also. This is something that what I could do, but there is a maximum. I could not make a Leonardo da Vinci painting, but if you have a wonderful brush, if even a stupid person like me takes it, no, an artist, take it into my hands, and it starts in 5 colors in parallel to do something wonderful there, this is still a tool, this is not me, but I have set it onto that task to make this painting in the style of Leonardo da Vinci. That's all. Sorry, a very long answer to a very short question. Sorry.